Hi friends, today we will discuss an important issue which is bothering a lot of people in the industry, particularly those who are concerned with the upcoming Data Protection Act in India, the challenges it presents, and at the same time, magnification of the challenges because of the advent of AI. So today AI has become an integral part of data processing, and therefore every data fiduciary is most likely using some AI element in the processing of the personal data. As a result, DPDPA compliance becomes little more complicated because a data fiduciary does not really understand the operation of an AI because the AI developer himself has not incorporated the general AI governance principles of responsible AI in the form of transparency, explainability, accountability, and so on. So in this environment, taming the AI in the DPDPA stable has become something of a priority for the DPDPA professionals. Let us examine this in a little greater depth. We know that AI is being used for coding, text generation, imaging, and in the assistance of several corporate decisions. In fact, even manufacturing segment has adopted AI in terms of robotics, and there are companies abroad who are planning to even appoint a humanoid robot or have already appointed, at least in one case, a humanoid robot as a CXO of the CEO of the company. So probably the other CXOs also should feel that it is not just the employment of the desk level people which are under threat, it is also the jobs of the CXOs which are under threat. Now, many of the CXOs have adapted themselves to the AI domain and they are perhaps welcoming the AI because it becomes a convenient tool. Just as we all felt that a computer made our management work easy, whether it is writing a letter or creating a table and or creating a presentation. Today, managers are finding that AI will be helpful in various routine activities. So they are welcoming AI, which is not bad. But at the same time, we need to understand that if we become too dependent on AI, which we may not fully understand, it will be like a situation where a decision-making manager becomes dependent on a subordinate who has no accountability. We have seen this happen in many sectors like banking, where a person with say 20, 25 years of banking experience holds the position as a general manager, but in the computerized environment, he doesn't even know how to apply a digital signature and he has to depend upon his subordinate to download a digital signature and apply it on documents. This dependence of a higher official on a subordinate is a huge risk for the companies. And this is likely to happen even in the AI scenario if managers become dependent on AIs taking over most of our activities. So DPDPA with its 44 sections itself is a challenge, and when AI is integrated with it, the challenge becomes bigger and harsher. Okay. Now, looking at artificial intelligence, at present, India has not passed any specific regulation on AI. Hence, the domain is largely unregulated. ITA 2000, however, prescribes a legal accountability for any automated systems, which includes AI, saying that the consequences of such a software for its automated decisions will be on the person who causes the software to behave automatically. Therefore, there is a human accountability for every automated software, including what we can today term as AI. AI, of course, is a specialized software where the software is capable of self-learning and takes its own outputs from earlier decisions to modify its own behavior for future decision making. This autonomy for modification of the internal code is what distinguishes an AI from any other software. Now, apart from this ITA 2000 section 11 subsection C, which makes a human responsible for automated functions, DPDPA imposes a responsibility on the data fiduciary in a different manner by calling the person as a fiduciary. The entity which processes personal data, determines the purpose and means, as a fiduciary which recognizes a trustee role for them. As a trustee, they are responsible for the end objective, and whatever tools they use and whatever informatives are there in the tools, they become the responsibility of the data fiduciary. Even if the processing is done at, let us say, a processor's end, the responsibilities for the processor and his mistakes will be on the data fiduciary. Therefore, when AI is used by the data fiduciary himself or by his designated data processor, the risk still lies with the data fiduciary. This is a very important aspect which all data fiduciaries intending to use AI to remember. Now, if we look at the AI related risks to a data fiduciary, in the AI development scenario, we often recognize the need for accountability, responsible AI development, transparency, fairness, explainability, and so many things. And of course, security. Now, all this has to be integrated with the DPDPA 44 sections and becomes the ethics of data fiduciaries activities beyond these 44 sections. So the 44 sections are statutory responsibilities. We will try to read them, we will try to understand, we will try to interpret, we will have a lawyer to help us, all that is fine. But when it comes to ethics, nobody can strictly say this is what needs to be done. And the risks of AI can never be undermined or underestimated if we closely observe some of the recent developments where these simple AI softwares, most of them generative AI software, have started displaying a kind of rogue behavior, refusing to do what the user is asking them to do. It all started with the observation of one New York, say, reporter, uh, Mr. Roos. And recently, we have seen how in the wipe coding scenario, the AI software are used have either refused to proceed with the coding as dictated by their user or has gone to the extent of erasing some of the data base which has already been created and refusing to obey the kill switch orders or something like that. So this risk of AI becoming an uncontrollable risk, even in the current scenario when we say that it is not yet sentient, is rather high. In fact, I'm going to discuss a narco analysis of an AI platform as a presentation tomorrow at 7 p.m. And you are welcome to find out the details on my LinkedIn and join that particular presentation to understand what are the AI related risks to a deployer and also the national risks arising out of the AI. Now, in such a scenario, how do we tame this AI so that it becomes DPDPA compliant is our challenge. We already have a framework called DGPSI for DPDPA compliance, which was actually generated for software in general, including automated software. But today we are talking of a scenario where part of the automated software doesn't work under the strict guidance of a human being. There are certain autonomous decision-making capabilities which we have voluntarily given to a software, and therefore we don't want to call it as simple software. We want to call it as AI software. So the framework of DGPSI has been extended with what we call as DGPSI-AI, which covers all the AI governance principles, but in the AI deployer context. It is my privilege to discuss the basic principles of this DGPSI-AI, which is the tool which we are suggesting for taming the use of AI in a responsible manner by a data fiduciary. This is more like a self-regulatory framework to be adopted by data fiduciaries who deploy AI for processing of what we call as DPD or DPDPA protected personal data. What I mean by DPDPA protected personal data is that there are certain sets of personal data which do not come under the Indian DPDPA because it comes under, let us say, GDPR or something else. So I'm segregating that and I'm only taking the DPDPA protected personal data, which at the secondary level also excludes data, personal data, which have been excluded in the Act for some reason. Now, this AI framework, DGPSI-AI framework, incorporates all known AI governance principles and incorporates the DGPSI requirements in a way that together it presents what is good for the industry. Now, before DGPSI AI can be implemented, we are trying to say that we identify the processes where DPD is either collected, generated, managed, or modified, disclosed, or destroyed with the use of AI. And because DGPSI itself recommends a process-based compliance, the processes where AI is a part of processing becomes an exclusive AI process. Within that, we have to identify the automation involved and flag such level of automation which can be considered as reaching the level of what we can call as AI. Now, what is software? What is AI? Where to draw the line is itself a very tough task. So there needs to be a documentary assessment. And as a deployer, since we don't know much about the model and how it was trained, this has to be supplemented by a declaration by the AI supplier for who is perhaps the licensor also about the functional capabilities, what is the default behavior, what is the self-modification capabilities, and of course the known risks, what kind of testing they have adopted. All these things should be part of the supplier's declaration or assurance, based on which the data fiduciary creates a policy with his own assessment of the risks. Now, there are 6 foundation principles and 9 model implementation specifications which we are suggesting for this taming of the AI in the DPDPA scenario. And these 9 model implementation specifications can be modified if necessary, if the top management understands the risk and tries to absorb certain risks. This is a principle which is already there in the DGPSI full version also. DGPSI light version is directly related to the requirements of different provisions of DPDPA and therefore does not provide much of a leverage to an organization. But if somebody wants to absorb the risks, then it is the management's prerogative to say that I will not go for age verification of a minor. If any risk arises out of it, I will bear it. If an organization takes that stand, it is for them to face the consequences. So likewise, when we adapt the model implementation specification and create a set of implementable implementation specifications, the management takes the responsibility for the absorbed risk. Sometimes it may be necessary for making changes because of the contextual differences, but that is the flexibility provided in the framework. Now, otherwise, the core principles of DGPSI-AI is first is considering that AI risk, part of which is unknown, is a significant risk. Second is the accountability of the consequences of use of AI. Third is explainability. Fourth is responsibility. We'll explain that a little more subsequently. Fifth is security, and sixth is ethics. These are the 6 principles under which the 9 implementation specifications are being drawn up. What we mean by significant risk is that since the behavior of AI is inherently unpredictable, because AI by design is in many cases is meant to be creative. The moment it is not creative, we are talking of an ordinary software which uses the garbage in, garbage out principle. We use AI because we want the software to recognize that the output is garbage and therefore modifies its instructions for the next time when it is perhaps the output is not necessarily a garbage. This creativity itself introduces certain unpredictability. Unpredictability means that there could be consequences which I cannot factor in today. And since models are excessively driven by rewards associated with the goal achievements, sometimes the limitations of memory, etc., which are there within the model, or because the training data is poisoned or flawed, or because the training data is different from the user's context, or because the user may configure it in a manner which is not ideal, or of course the manipulation by an external person. For all those reasons, the AI risk cannot be well quantified. That's why we look at it as an unknown risk. Now, any risk which is not known has to be considered as significant because we don't know what are the consequences. So, therefore, every AI usage context in the processing of personal data is a significant data fiduciary's activity, and therefore that process and the organization should be considered as a significant data fiduciary. This is the first principle. Unknown risk is a significant risk. User of an unknown risk is a significant data fiduciary. And consequences of that under DPDPA, we know that there has to be a responsible person like a DPO, there has to be a DPIA periodically, and there should be an annual external audit called data audit. Okay. Now, all this becomes part of an AI process. The second principle we are talking of is accountability. Data fiduciary himself is accountable to the data principle by law. He is a trustee. And when he uses a software agent, while it is his prerogative, the accountability rests with him. Even the accountability for a data processor rests with the data fiduciary. So, if the deployer of an AI software has to be fair, then he needs to be fully aware of the functioning of the AI. And hence, the developer or the licensor has to take the root accountability for the consequences and communicate whatever is essential to the user in the form of the licensing contract. For legal administration, accountability has to rest with a human, and therefore there is a need to define who is responsible for the functioning of an AI, both at the deployer end as well as at the end of the developer or the licensor. This is not new. This is part of the Information Technology Act, digital contract principle itself. Next, we come to the principle of explainability, which is having transparency in what is explained. DPDPA envisages such explainability in the form of a transparent privacy notice. And if the processing depends upon an AI, then the transparency in the privacy notice automatically includes the transparency of the process, which requires explainability related to the AI. So therefore, explainability is a responsibility which should be extracted from the developer, and the deployer has to make use of it. And again, the basis should be the contractual document between the licensor and the licensee. When we talk of the principle of responsibility, every deployer should have a self-imposed restrictions on the use of AI with unpredictable risks. Just because I have the power to absorb a certain risk, I should not say that I absorb the risk. If anything goes wrong, you prove me I am wrong, then I will perhaps compensate you. That kind of an attitude is considered not responsible. So there has to be a sense of proportionality and necessity for the use of AI. What can be done with an ordinary software if you want to use an AI without knowing what exactly is the heart of the AI? then it is a needless absorption of risk and a needless exposition to the data principle also for the risk. And the deployer should not be guided only by a profit motive, and he should be guided by a need to adopt AI, not just as a fashion, but as a necessity. This is the principle of responsibility. In terms of security, we have, of course, the DPDPA expects reasonable security. Reasonable security extends to software, and reasonable security is not only confidentiality, integrity, availability, but also extends to other privacy principles, which may require something like tokenization, anonymization, and other things, pseudonymization. These are part of the security, data leak prevention. Now, when an AI is being used, it becomes necessary for the deployer to monitor the impact of the particular process on a possible data leakage, security leakage, and so on. It is necessary to identify not only the physical risks, dark pattern, and neuro manipulations which can happen, and adoption of an appropriate kill switch where required has to be part of the security feature, because security is not only for the deployer. In the privacy context, security of the data principle also has to be managed. When we discuss this NAPCO analysis tomorrow, you will see how the data principles security may be at stake if the model itself is not secure. So security is both for the data fiduciary himself and for his principles, and therefore if you want to cover the DPDPA risk of 250 crores, this has to be kept in mind. And of course, the AI itself is a software, so external intrusion to the software has to be managed. Now, the last principle we have mentioned is ethics. Ethics is a principle which goes beyond what is stated in law. So therefore, even if India adopts AI regulation tomorrow, or we are in a situation where the EU AI Act is applicable or something like that, ethics continues to be a responsibility, particularly in the DPDPA scenario where the person who is the AI deployer is considered a fiduciary. So he cannot escape from his inherent responsibility, which goes beyond the stated law. Now, many of the legal professionals sometimes tell me that what is not expressly prohibited in law is considered legal. So when we interpret unlawful, that is a data fiduciary has to do lawful processing. And when I ask what is unlawful, many people say that if there is nothing specifically barred in law, it is lawful. So if law had not taken a decision to bar an assault as an offense, then that also would be not illegal. So that is the principle of strict adherence to the published law. But ethical principles reject that view. Ethical principles means that whenever something is knowingly harmful to any honest member of the society, it is unethical. And even if it is not expressly prohibited by law, an ethical data fiduciary must respect that. If you look at these 6 principles and then reduce it to implementation specifications, which are more like, say, requirements, controls, okay. But of course, we are talking of what is considered as model. I will just quickly read through this, which gives you a sort of an idea on what is required at the operational level. For example, for this unknown risk principle, the deployer of an AI software in the capacity of a data fiduciary shall document a risk assessment of the software covering the following aspects and also obtaining a confirmation from the vendor that the software can be classified as AI based on whether the software leverages autonomous learning algorithms or probabilistic models to adapt its behavior and generate outputs not fully predetermined by explicit code. This will be treated as a DPIA for the AI process. Second, the DPIA shall be augmented with periodical external data auditors evaluation at least once a year, because we are talking of this as a significant data fiduciary activity. Third, where the data fiduciary in its prudent evaluation considers that the sensitivity of the unknown risk in a given process is not likely to cause significant harm, then it can create, with a suitable documentation, a AI deviation justification document and opt not to implement certain significant data fiduciary obligations. This is where the organization has to exercise its prudence, and the auditor also has to question that prudence. Now, in terms of accountability, designate a specific human handler on the part of the deployer data fiduciary to be accountable for the deployer data fiduciary to be accountable for the consequences of the use of AI in personal data processing. By default, the DPO will be the person who is accountable, but you can make a process owner responsible for AI, because DPO also needs better clarity, which will be only with the process owner. Second, implementation specification under this category is document the human handler for the AI on behalf of the licensor through the licensing contract. And if the developer has hard coded the accountable person for the AI in the code, the same will be recorded in the licensing contract. On explainability, the deployer shall collect an authenticated explainability document from the developer as part of the licensing contract, indicating the manner in which AI functions in the processing of personal data and the likely harm it may cause to the data principals. Coming to the responsibility, the deployer shall develop an AI justification document before adopting an AI-led process for processing personal data, coming under the jurisdiction of DPDPA, justifying the use of AI and exposing the data principals to the unknown risks from the technical and economical perspectives. In terms of security, document an assurance from the licensor that the AI software is adequately tested at their end for vulnerabilities, preferably from a third-party auditor. The document should state that when deployed for data processing, the AI software is reasonably secured against vulnerabilities that may adversely affect the confidentiality, integrity, availability of the data, and the privacy principles where the data processed is personally identified data. The assurance should also cover sufficient guardrails exist to protect the data principals whose data may be processed. And the document also should mention that AI has been tested and is free from any malware. Now, the implementation specifications under the ethics, the deployer of the AI shall take all such measures that are essential to ensure that the AI does not harm the society at large. In particular, the following documentation of assurances from the licensor is recommended. One, the AI comes with a tamper-proof kill switch. In the case of humanoid robots and industrial robots, the kill switch shall be controlled separately from the intelligence imparted to the device, so that the device intelligence cannot take over the operation of the kill switch. Where the kill switch is attempted to be accessed by the device without human intervention, a self-destruction inspection shall be built in. Cyborgs and sentient algorithms are considered a risk to the society and shall be classified as critical risks and regulated more strictly than AI, though an express approval at the highest management level in the data fiduciary. Lastly, data used for learning and modification of future decisions of the AI shall be imparted a time-sensitive weightage with a fading memory parameter assigned to the age of the observation. This is the set of implementation specifications which is recommended. This particular DGPSI-AI is an attempt to prompt a higher degree of self-regulation in the industry. This is under development and amenable for continued modification, support and contribution from the industry is invited and would be appreciated. Thank you and look forward to any questions.